Have you ever wondered about the digital safeguards protecting student information in our schools, especially as technology like artificial intelligence becomes more common? It is a big question for educators and parents alike. Schools comply with state student data privacy laws primarily by implementing robust policies and practices that govern the collection, use, sharing, and protection of student personal information. This involves a multifaceted approach to ensure compliance and build trust within the educational community. The core reason for these stringent laws and compliance efforts stems from the fundamental right to privacy and the sensitive nature of student data. State laws like the Student Online Personal Information Protection Act, often called SOPIPA, and federal acts such as the Family Educational Rights and Privacy Act, known as FERPA, establish specific requirements. They aim to prevent unauthorized access, misuse, and commercial exploitation of student data, ensuring that information collected is used solely for educational purposes and with appropriate consent. One key step is conducting thorough data inventory and mapping. This means identifying exactly what student data is collected, where it is stored, and who has access to it. Next, schools must implement clear data governance policies. These policies define roles and responsibilities, establish data retention schedules, and dictate data destruction protocols. Another crucial aspect is vendor management. When schools partner with educational technology providers, especially those incorporating artificial intelligence, they must ensure these third-party vendors are also compliant with all relevant privacy laws. This often requires strict data privacy agreements outlining data use limitations, security measures, and incident response plans. Regular staff training is also essential. All personnel who handle student data, from teachers to administrators, need to understand their obligations under state and federal privacy laws. This includes recognizing potential privacy breaches and knowing the correct reporting procedures. Furthermore, schools actively engage with parents and guardians. They provide transparent notices about data collection practices, obtain necessary consents, and offer mechanisms for parents to review and request amendments to their child's educational records. A common insider term you might hear in discussions about student data privacy is de-identification. This process transforms personal data so that it cannot be linked back to an individual student without additional information. While not always a complete solution, effective de-identification can allow for valuable educational research and analytics while significantly reducing privacy risks. It is a complex but powerful tool when applied correctly and in accordance with legal guidelines. By proactively establishing comprehensive data governance, rigorously vetting educational technology vendors, and fostering a culture of privacy awareness among staff and parents, schools can confidently navigate the evolving landscape of state student data privacy laws. This diligent approach not only meets legal mandates, but also fundamentally safeguards student well-being and maintains community trust, ensuring that innovation in education never comes at the expense of privacy.